rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in the Andover within the Commonwealth. Your name and your tendency shall be heard. I say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. Can you hear me? Do I need the microphone, or can you hear us all? Well, we'll find out. Well, welcome to this special sitting of the Massachusetts Appeals Court. It's special only in the sense that we are out of our beautiful John Adams courthouse. It is otherwise a completely ordinary sitting of our court. My name is Gabrielle Wolohojian, and it is my great pleasure today to be sitting with Justices Neyman on my right and Justice Shin on my left. I want to say a couple of words at the outset of the session today. First of all, thanks to our hosts for making this sitting possible. Thank you so much to our court personnel. This is a tremendous effort on their part to make this possible as well, and we really appreciate it. I want to thank in particular the lawyers for making the effort to come and argue here. You are making it possible for the court to continue its educational mission by doing so, and we really appreciate it. I want to welcome our friends and students at the Mass College of Law. We look forward to conducting one of these sittings again at your school in the near future. I want to let everyone know that the argument is being recorded. It will be available for viewing later on the court's YouTube channel. And as a warning, I'll also say to the lawyers, as usual, if there's any portion of your case that's impounded or partially impounded, just to be aware of that, because we don't mention that in open court. We have 3 cases on the list this morning. I know that many of you have been told there were 4, but one of the cases needed to be postponed because the lawyer was sick. After the 3 cases, and we don't anticipate taking a morning recess in between the 3 cases, I hope you'll stay for a question and answer period, which will conclude by noon, maybe 10 minutes to noon, at which point we plan to take a 10-minute bathroom break and then be back here promptly at noon for the Zoom session and the expanded panel with other judges and students of Phillips Academy. As usual, there will be 15 minutes allotted to each side to argue. There is no rebuttal. The yellow light on the podium will go off about 1.5 minutes before the end of your argument so that you have a sense of timing to wrap up. And there is no rebuttal. So with that, I am going to call the first case on the list, which is case number 2022P0792, Commonwealth versus Thomas Elwell. And is it Attorney Ganguly?
Ganguly.
Ganguly. Every time you appear, I mispronounce the second
You'll
G.
get it the next
I am so sorry. All right. We're ready whenever you are.
Good morning. Tara Ganguly for Mr. Thomas Elwell. Your Honors, the trial court judge in this case made 2 legal errors, both of which require reversal of my client's conviction. First of all, the trial court abused her discretion in denying Mr. Elwell's motion to impeach Mr. Lovett with his prior conviction. The judge did not analyze the necessary factors and did not properly balance the probative value of the evidence with its potential for prejudice. The SJC in this area of the law has specifically rejected a rule that would allow for impeachment with evidence of prior convictions only for crimes involving dishonesty, false statements, or moral turpitude. In this case, the trial attorney was trying to impeach the witness with a conviction for larceny from a building.
Before we get into the substance of your argument, can we get settled on the standard of review here?
Sure. So
Let me just finish. You said that because there was no objection, the court reviews to see whether there was error, and if so, whether there was a substantial risk of a miscarriage of justice. But looking at the transcript, it's volume 2, page 103, it appears there was a pretrial motion filed by defense counsel to allow these convictions in, correct?
there was I believe it was it was a handwritten motion. I believe it was the first day. There was some discussion with the judge and the parties regarding whether it was timely filed. The trial attorney indicated maybe he should have filed it sooner, but he was filing it now.
Was it akin to a motion in limine?
I think it was akin to a motion in limine, yes.
Okay, so if so, why is that not properly preserved for appeal under Grady?
Your Honor, if you want to say it is, that's better for me. I think
Well, what I really want to know is what you think it should be.
Well, because the trial attorney did not object after the court's ruling, I thought that it was substantial risk, but now thinking of Grady, which is more recent regarding these standards of review, it may in fact be prejudicial error.
Well, Grady does say that the argument that was raised before the trial court has to be the same argument raised before us, before the appellate court. So I saw the only argument that was raised below was that larceny from a building is in fact a crime related to truthfulness and dishonesty. Would you agree with that? That was the argument that was raised to the judge?
I think the argument raised to the judge was that the type of crime that you can impeach someone with is wider than just a crime relating to dishonesty or truthfulness. Whether larceny from a building is more, if you want to think of it more as an honesty crime, I can see that, but I think the trial attorney was actually thinking of it more as a burglary crime or taking property and not necessarily a lying crime. My argument is that it doesn't matter what type of crime it was.
What are the elements of larceny from a building?
Taking from a building, it's not breaking and entering, it's just a taking.
It's just a taking. So, and how long before the trial did that larceny take place?
I believe it was definitely within the statute. I know the docket is in my record appendix. I don't remember off the top of my head whether it was within 5 years or 10 years.
Okay,
But
but you think that, is it the nature of the crime that you think tied it sufficiently to this case that would mean that the judge abused his or her discretion in excluding it, or is it something else about the conviction that you think
it falls within Chapter 233, Section 21. There was no question about that. And it's not necessarily the nature of the crime, it's that this person was convicted of a crime within the time frames of this statute. Therefore, the defendant has the right to impeach him with that conviction and allow the jury to assess his credibility based on that.
Okay, so I think what you're saying is that the judge committed an error of law by using an incorrect legal standard in assessing the admissibility of the prior conviction.
Correct, Your Honor.
But the judge still has discretion to exclude a conviction, right? Even if it falls under the statute.
Correct.
And one of the elements that the judge is supposed to, one of the factors the judge is supposed to consider is whether the crime does relate to honesty and truthfulness.
That is one of the factors, but the judge in this case really didn't get beyond that at all. The judge basically said, well, this isn't a lying crime. So it's not a lying crime, so it's out. That's it. So
what else should the judge have considered in this? I mean, usually the conviction that is sought to be admitted is it's usually the defendant's conviction, right?
Right.
So in this context, what else should the judge have considered?
Well, in the defendant's, if it was in the defendant's context where the defendant was being impeached with his prior conviction and he was testifying, it would be whether the prior conviction, how similar that prior conviction is to the crime for which the defendant is now charged and on trial. I don't think that that's a factor where it's a witness. I haven't seen any cases where the case law discusses it in that, where it's a witness testifying and not the defendant. But in any situation, the court is supposed to balance the probative value of the evidence, should it be admitted, with its potential for prejudicial harm, and the court did not do that in this case.
Further to Justice Wolohojian's question, are you making the argument, though, that larceny from a building is a crime that bears on truthfulness, or are you not making that argument?
I am making that argument as a subsidiary, I suppose. My main argument is that it falls within the timeframes of the statute, therefore it should have been admissible as impeachment evidence. And also, it is a crime tending toward honesty or dishonesty. The trial attorney for Mr. Elwell didn't quite go that far as I would go now, but I do believe so.
Do we have to just accept, do we look at, on review, just the nature of the crime itself, or are we supposed to look at the underlying facts of the crime to determine whether or not it bears on truthfulness and honesty?
I don't believe you're supposed to look at the underlying facts. It's just the fact of the conviction itself.
Okay. No, go ahead.
Are you contending that there's any particular relevance, just as opposed to just it falls within the statute, of this crime and the prior conviction and this crime that was on trial there now? Is there any particular relevance other than it's a prior conviction and it bears on the witnesses, and therefore it bears on the witnesses' credibility?
No, I don't believe it has any relevance to the armed robbery which Mr. Elwell was being tried for. The brief mention of them knowing each other from jail would be the only other tie-in, I assume.
Right, I wanted to ask you about that because, oftentimes the prejudice that flows from admitting the prior conviction is that the person you're admitting, whose prior conviction it is, maybe their credibility is diminished just by the fact that they've been previously convicted of a crime. But in this case, the witness said that he knew the defendant because they had both been in jail together.
Correct.
So I think the only reasonable inference from that is that the witness had been previously convicted of a crime. So if we're looking at the prejudice, the impeachment value of the previous conviction, what did it add to the knowledge the jury already had that this witness had been previously convicted of a crime?
So I would push back slightly, Your Honor, on that being the only inference based on the testimony that they knew each other from jail. I mean, I don't know how many people in general, how the general public on a jury would evaluate that testimony, but you and I and anyone who works in the criminal justice system knows that someone can be in jail held pretrial and not be necessarily convicted of a crime. So I don't think the evidence of, we knew each other from jail, maybe they had been held, maybe he had been held pretrial. We don't know. So I think the evidence of the conviction itself would be stronger.
Do you want to turn to your other argument?
Yes, Your Honor. So the consciousness of guilt instruction. This one, I do believe that it was properly preserved. So my feeling about my client's statements and his interview with the police and the exhibit of that redacted interview that was admitted at trial is that, yes, he was wishy-washy at first about whether he knew Tristan Lovett, whether he had been to Lynn sometime in the past few weeks. But he did, after a few minutes, say yes. Oh, yes, I do know him. I remember him. Well, actually, I was on Highland Avenue in Salem, not Highland Avenue in Lynn. But where I think the court was going in terms of the consciousness of guilt instruction having to do with, quote unquote, false statements to the police was his statement about whoever Spades was. And because we still don't know who Spades was. One of the police officers testified that it was this person named Austin Kavanaugh who was eventually determined to not be involved in this incident at all. So my argument is that the alleged falsity of my client's statements having to do with who Spades was, and Spades was, holding a knife to me and I was under duress and all that, that the jury was somehow not supposed to believe that because we had a police officer get up there and testify. We determined that Spades was this other guy. He was a white guy, and the victim said that it was a Hispanic guy who was involved in this, so it couldn't have been him at all. And therefore, the implication is that Mr. ELWELL lied to the police in his statement when he referred to Spades.
Well, let's drill down on that. In your brief at page 20, you state, because the defendant's statements to police were not necessarily false, the court erred in giving the jury an instruction on consciousness of guilt. Is necessarily false the correct standard? And I ask because it seems to me that only the finder of fact, only a jury really determines whether or not something is necessarily true or false.
The jury certainly is the final predominant fact finder, but in just giving the instruction, the court has a gatekeeper role? Essentially, the court is saying, I think there's enough possible evidence for you to find that there is actual evidence of false statements. It's, yes, essentially a gatekeeper role.
So what of the fact that defense counsel in closing said, look, my client lied when he said he did not know Mr. Lovett?
He may have lied, yes, he certainly lied at first about that, but I don't think that was the most important part of the 6-minute statement that was admitted, because he very quickly changed his tune and admitted that, yes, he does know that person.
But isn't it up to the jury to decide what value and weight to give to the conflicting or the shifting statements? The consciousness of, you're not arguing that there was anything wrong in there was any legal error in the consciousness of guilt instruction as it was given, correct?
Correct, not the instruction.
You're just arguing it shouldn't have been given because the facts, the evidence at trial didn't support giving the instruction.
Yes, Your Honor.
But the instruction said to the jury, told the jury that it was up to them to decide whether anything the defendant had said was false. And only if they did so did it tell them that they could, but were not required to use that as a potential inference of consciousness of guilt. So where the instruction reserved to the jury the fact-finding role of determining whether the statement was false, what's the problem here?
The problem is that the instruction, I don't believe there was proper evidence for the instruction. So if the instruction essentially lifted up the victim's side of the story in detriment to the defendant's side of the story, and without the instruction, I believe they would have been more on equal, obviously the defendant didn't testify, but there was a recorded statement, and those statements could have been evaluated more equally, in my opinion.
All right, thank you. Let me see if there are any further questions. All right, thank you very much. We have your argument. Attorney Mello?
May it please the court, Emily Mello on behalf of the Commonwealth. Excuse me. So I'll begin with the first issue here. As you know, there are two issues before the court. It's whether the victim's conviction should have been admitted for impeachment value. So here, the victim had a 2014 conviction for larceny from a building, which is a felony within 10 years, so under the statute, admissible. However, it is, even if the conviction is potentially admissible, it is within the court's discretion to determine whether to admit it.
Is that discretion influenced in any way by the fact that in this case, it's the defendant seeking to use the evidence on cross-examination of one of the Commonwealth, so really the key witness of the Commonwealth? And I'm thinking in particular, do we need to keep in mind that there's a constitutional dimension to cross-examination in that context?
Sure, of course, there's always a constitutional dimension to cross-examination, but cross-examination, like everything else and all the evidence that comes in at the trial, is to the court's discretion. And here, and I do think it makes a difference.
I don't think it's within the court's discretion to infringe upon a constitutional protection.
No, absolutely not. No, I'm sorry. And if that's what it seemed like I was saying, then I completely misspoke. But cross-examination, like everything else that happens in the trial, is open to some discretion by the court. And as it says here in Commonwealth v. Harris, that even if a conviction is admissible under the statute, it is open to the court's discretion. And there are several factors that the court can look at in exercising that discretion. Some of the factors don't apply because, as one of your honors had pointed out, usually it is trying to bring in a conviction for the defendant. So some of those factors that are sort of defendant-specific don't apply in this situation, but there are factors that do apply, which would be whether the conviction is a crime implicating truthfulness, whether there are other prior convictions that could be used, and whether the judge conducted the required balancing test. I would say here, the judge did consider the conviction, and she decided that within her discretion, she was not going to allow it in. She felt like the probative value was small in this particular instance.
What would be the prejudice to the Commonwealth if it was admitted?
I think the prejudice to the Commonwealth, I guess, would be sort of an unfair inference that the witness is not credible. And I'm not saying that the judge couldn't have let it in. She absolutely could have. It was just within her discretion to determine that it was not very probative in this case. And I don't think it was very probative in this case, but even if this court were to find that it was an abuse of discretion, I don't think that there was any prejudice to the defendant where there was testimony on several occasions that the defendant and the witness knew each other from jail. And I think that anyone on a jury or anyone in the general public would assume that if you were in jail, you have been convicted of a crime. And there was a curative or a limiting instruction with respect to the defendant and him having spent time in jail, and the jury was properly instructed they could not consider that as affecting on his character. But there was no similar instruction for the witness. The witness was who he was, and he had conflicting statements, and he had obviously been in jail before, and all of this was put out in front of the jury. And then it was for the jury to decide whether or not he was credible and whether or not they believed him. And
I'm going to interrupt you.
Sure.
You've used the term abuse of discretion several times now. This case, during this case, defense counsel brought a motion, it seemed to me like a motion in limine, a pretrial
Correct.
motion, even though it was brought after the jury had been sworn, but before the first witness testified, correct?
yes, that's correct.
So under Grady, which you cite in your brief, the issue is preserved?
I would agree that the issue is preserved,
Okay.
but I think that the proper standard of review is abuse of discretion.
It would be abuse of discretion and a not substantial risk.
Yes.
Okay. The next question I have for you is larceny from a building a crime that bears on truthfulness?
I think it can. And
So if it can, I'm sorry for interrupting you again, but let me get to the crux of the question. If it can, how is that to be decided at trial? Is it when a party seeks to introduce a prior conviction to impeach a witness? Is the judge supposed to just look at the face of the conviction
Yes.
and make that determination whether it bears on truthfulness? Or is there supposed to be a proffer of underlying facts to let us
No.
know what exactly happened in the prior crime?
the former.
It's the former.
It is the former. And
Well, what if the crime is ambiguous? I mean, some
that's why it's
cases.
within the judge's discretion.
Wouldn't it be better, though, to require the parties to explain the underlying facts of the prior conviction, and that way we would know whether it bared on truthfulness or
think-
bore on truthfulness or not?
I don't think that would be appropriate. That's certainly not what the standard is or what the statute suggests. That's not how it's ever been done. It's not done like that when it's the defendant's conviction. It's just, are you so-and-so who has been previously convicted of, and that's the same way it's done with the witness. There is no going into the underlying facts. I would agree that there is some case law to suggest, and I do cite it in my brief, that a larceny theft type of offense could implicate truthfulness. The judge did not
Which the judge
agree with
seems
that.
to, well, right, that seems to be an error on the part of the judge.
I don't know if I would call it an error.
The
There is
judge
some
didn't
case
think-
law to suggest
The judge
that.
did not think that larceny from a building was a crime involving truthfulness, period.
Yes.
And didn't delve into the underlying facts of this particular prior conviction to determine whether in this case it might have been. So how could the judge have correctly determined, sort of per se, that this particular prior conviction was not a crime bearing on truthfulness?
Well, I don't think that you are allowed to delve into the underlying facts. It is just
Okay,
the
then
fact of the
judge
conviction.
presumably needed to accept the law that larceny from a building does bear on truthfulness.
I don't think that it is quite that settled. I think there's some law to suggest that larceny from a building and theft offenses could implicate truthfulness. I don't think that it is completely settled
What do you
law.
mean by could? If you're not going to look, as you just said,
I see your point.
at the underlying facts, then either it is by the nature of the conviction or it's not. Or else, if there's some discretion there, then it seems to me you would need to see the underlying facts in order to exercise that discretion. I don't see how it can be anything other than that.
I do. I see your point. So let's say that the judge was wrong and that it was a crime that implicated truthfulness. That's not the only factor, and she still did say that I believe that the probative value of this conviction is de minimis. And so I believe that was within her discretion. But even if the court were to find that it was an abuse of discretion, there was no prejudice because the jury knew that the witness had been to jail.
So if the judge had allowed the motion, what additional evidence would have come in?
It would have just been, the defense attorney would have asked the witness on cross-examination, are you the Tristan Lovett who was convicted in 2014 of larceny from a building? And he presumably would have said yes, or he could have said no. But that's what the additional evidence would have been.
The fact of the
Yes.
conviction in 2000.
And I don't think that based on the fact that the jury knew that he had been in jail, I don't think the fact that they now know what that conviction was for was going to make a really big difference in the calculation. There just wasn't any prejudice here.
If the witness had said no, then the prior conviction itself could be admitted as an exhibit for the jury, right?
You're getting very specific. I don't think so.
You also said you can't delve into the underlying
Yes.
facts of the conviction. What authority do you have for that proposition?
Geez, I can certainly file a 16L with respect to that. I just know from trial practice that that's not permissible. But I'd be happy to file a 16L if the court would be interested in that.
No, it just seems strange to me that a judge has discretion to rule on something where they don't know. So forgery, yes, it comes in. Assault and battery, it doesn't come in. Larceny from a building, yeah.
But
I'm feeling like it bears on truthfulness. I mean, that doesn't seem like the way a judge should be operating. That seems almost whimsical.
And I don't think that's the calculation. I think that the calculation is more the fact of the convictions and how much probative value that's going to have. And like we were saying before, it's usually the defendant. So, for instance, if you have a defendant or a witness, I suppose, that has 25 prior convictions, like the judge usually isn't going to let you sit there all day and say, are you the so-and-so who was convicted of this? Are you, like, at some point it gets redundant, prejudicial, unfair. So the court does have discretion, and that's the way that our statute is set up.
Right, that's almost an easier case, right? So if you have a witness who's not the defendant, who has a single conviction, most of the factors laid out in the cases don't even apply, right?
I agree.
So
It's
then
not
what
the
are the
usual case.
parameters on the judge's discretion? That's what's a little bit puzzling about this case.
I think it's, I guess, mostly a 403 type of balancing test. And I will just say that, again, I know I said it before, but even if this court were to find that the judge abused her discretion, I think the probative value not only was very small, but there was no prejudice where the jury already knew that the defendant had been in jail. The only probative value of this conviction is to say, because you are, and this is, the cases say, the fact that someone was willing to, previously convicted might show that they would not take the courtroom oath seriously. And that's the point of the statute. So what you have here
Well,
is...
I'm sorry to interrupt you.
No, not at all, please.
The conviction was 7 years before trial.
Yes.
Correct?
That's correct.
And it seems to me the defendant might have been able to argue that the victim's ability to identify the defendant, given that there was a remove of 7 years since the last time he had seen him, even if it wasn't jail, would have helped the defendant.
I think he could have argued that anyways.
Sure, but he couldn't because he couldn't get the conviction in.
Well, he got in that they knew each other from jail, and he could have
But
said, when
not
was
the
that?
timing, right?
Well, he could have said, when were you guys in jail together? I mean, there's not an ineffective assistance claim here, and certainly
But
he could have...
tried to get the information in through the conviction. which would
But he
given
could
him
have
the
also got the
timing.
information in by saying, and when was that you guys were in jail together? And that's not the tack that he took. The tack that he took was, it was made up. And look at how he's inconsistent. He's saying it's a gun, now it's a knife. And that's the defense he took, and it was not successful.
Do you want to turn to the instruction?
As to the consciousness of guilt instruction, here there was ample evidence to support a consciousness of guilt instruction. When a defendant makes potentially false statements to the police, that can support a consciousness of guilt instruction. Here there was an interview with the police. Portions of that interview were played for the jury. The defendant initially denied knowing the victim, only to later admit that he knew them, again, because they were in jail together. And he explained that, and when he was confronted with, well, why did you say that you didn't know Mr. Lovett? He said, oh, well, now I see a picture of him here in your paperwork. And the detective said, well, there is no picture of him in the paperwork. Again, a lie. Then he denied having been to Lynn recently. He said, I don't go to Lynn. I haven't been to Lynn. And then when he was confronted with Mr. Lovett's version of events, he then completely changed his story and said, no, that did happen. I was just coerced by this other person into participating in the robbery. So, and also, just briefly back to that first issue, with that as his defense, he's not saying, I wasn't there, I didn't do it. He's saying, I was coerced into it. So I don't think, even with that defense, the probative value of that prior conviction becomes less and less.
All right, I think we'll have to leave it there unless there are any other questions? No. Thank you both for your argument.
Thank you very
The
much.
case is submitted. We're going to take 1 minute so that if there's anyone who wants to come or leave from our courtroom may do so. And the attorneys are more than welcome to stay if you'd like to stay or leave. Yeah, counsel for the next case should feel free to come on up. We're just going to wait until everyone has a chance to come in and out of the courtroom. Oh. Okay, thank you. And I had promised to give that same short interval in between each lawyer's argument, but I forgot in the last case. So maybe we'll just do that this time because there are a lot of many people needing to go in and out. So our next case is 2023 P0144, Commonwealth versus Aaron Guerrero CANTU. And is Attorney Taitano? Taitano. Thank you. We're ready whenever you are.
Good morning, Your Honors. Eric Taitano for Mr. Aaron Guerrero CANTU. Your Honor, the appellant brings two issues before the court. The first is the joinder of the two cases. One of the cases being a domestic violence case where the defendant was charged with assault and battery, dangerous weapon, assault and battery on a family household member, as well as threats. And the second case was a violation of two charges of a restraining order that was issued after a February 7th incident regarding the alleged domestic abuse, Your Honors. The motion was brought on the day of trial by the Commonwealth to join the two cases, and defense counsel seasonably objected to that occurring on the date of the trial. What happened in this particular case, the misjoinder of the two cases respectfully cast a sort of cloud on the defense for Mr. CANTU, in that the restraining order was reflective of the incident on February 7th, sort of endorsing those facts, and the court giving it sort of endorsement of that those facts occurred on February 7th, and then by having the restraining order heard at the same time, just prevented Mr. CANTU from having a fair trial at that time.
How much time was there between the incident that gave rise to the, I'll just call them the assault and battery type convictions or charges, and the 209A charges?
Your Honor, there was a little bit over, I think, about 6 weeks difference in time between the two.
And both incidents involved the same people?
Yes, Your Honor.
Okay.
Yes, Your Honor.
So now, taking that time frame and accepting that the same people were involved, what's your closest case with a similar set of facts where we've said that the cases were improperly joined?
Well, the cases that I cited in my memo were of a little bit longer distance in time as far as that, but it went more towards the modus operandi or pattern of conduct. So,
but those cases were a little bit different. They were, excuse me, usually multiple victims, let's say, different victims, where the defendant is alleged to have used a similar pattern of conduct over a course of time.
Yes.
All right, so this is a little different because it's not the same conduct on two different occasions, but it's sort of related because it's sort of related to the relationship between the parties and the nature of their relationship, and it's the same people, and it's a short period of time. So I'm trying to figure out, do you have a case that's sort of close on the facts to this one, where we've said that the various charges should not have been joined?
Well, not specific with regards to the time frame period, Your Honor, but these two particular cases were completely distinctive. The assault and battery, although the Commonwealth wants to argue that this was an incident where it's a complex relationship and it sort of gives the context of the relationship, I would vehemently disagree with that. What occurs in this particular case is that and I don't want to blame the alleged victim in this particular case, but she's sort of the alleged instigator. What occurs in these particular two instances, Mr. CANTU is trying to avoid his wife at that time, is actually extricating himself from these situations and trying to say, hey, I need to get away. I don't want something bad to happen. And she then pursues him on both of these particular incidences. With the assault and battery, he was over living and sleeping at the Home Depot in one of his cars. He didn't go and start a particularly violent incident. And I understand she wants to address the sort of infidelity issues, but she's going over there and then sort of, and I don't want to say instigating, but she wants to address the issues, and that's what's causing the criminal charges to come forth at that point.
Well, I think she does put herself in proximity to him.
Well, absolutely, and obviously proximity doesn't allow anyone to touch anyone at that point or to commit an assault and battery.
Right, you can't get beaten up just because you...
Absolutely, but...
Can I ask you a hypothetical?
Yes, Your Honor.
Let's say that on the first day, the day in the Home Depot parking lot, there had actually been an outstanding 209A restraining order prior to that. So that not only was he charged with the A and Bs that he was charged with, but he was also charged with violating a 209A violation. Could all of those have been tried together?
Your Honor, that's an excellent scenario that you presented before me. I think it's sort of, yes, I think they potentially could have been tried together at that point.
There wouldn't have been a misjoinder issue there.
I wouldn't have suggested at that point.
Okay, so it's really the 6 weeks.
Well, it's not just necessarily just the 6 weeks, Your Honor. It's that the fact that the restraining order was given based on the facts of the February 7th incident. So it's sort of the court saying, hey, we're giving you this restraining order, and we're sort of endorsing that we not sort of put our stamp on, but we, sort of think that the February 7th incident occurred, because there is a standard in order to issue that.
It's not the restraining order standing alone, right? It's the violation of the restraining order. So where the defendant and the victim agree that on the timeline of events, but the question really is, who instigated the incident? Why isn't the later incident relevant to that?
Well, I would suggest respectfully, I'm not saying that the latter incident isn't indicative of who was sort of instigating or starting these incidences. I wouldn't argue that point, but what I would respectfully suggest at that point is that the taken of itself, the second incident, Mr. CANTU is alleged to have accidentally come upon his wife because he's going to his Volvo, which is parked at the Home Depot. And quite honestly, at that point, I would suggest respectfully, the facts weren't that strong. They said everyone agreed, he came here accidentally, he sees her, and then he decides to make his way out of there. He is with the alleged mistress at that time, where she gets out of the car, but what the Commonwealth pointed to at that point in their argument is that, well, he stopped and started taking a video of his wife, and I would suggest respectfully, he says that he left, but even if he did take a video at that particular moment, and a lot of instances with video cameras and everyone having a phone, it's sort of for defensive purposes to show.
But the victim is saying that he took the video
Yes.
essentially to mock her, right?
Yes.
Okay. Had there been a trial on the earlier incident, separate trial on the earlier incident, could the testimony about the video have come in without the evidence of the 209A order?
Well, if the first trial is strictly based on the alleged violent acts, there's no reason for.
But why isn't the later incident, if the jury believes the victim that he was taking the video to mock her,
Yes.
why is that not relevant to his intent during the first instance?
Well, respectfully, I don't think any of these incidences were going towards his motive or his intent.
Well, maybe I misspoke. I mean, you were saying that the issue is who instigated the incident.
Well, I did, and I apologize, I did mention earlier that I was saying that when I was talking about the common scheme or pattern, what the court noted when I was talking about different victims, different, same defendant, that really went to the person's motive and intent to try to demonstrate that to the jurors. And I was saying that's not the case here, because in this particular case, none of this goes to my client's motive or intent, because he wasn't the person, instigating or the person trying to have these incidences occur. And I'm not saying that she wanted it to occur either, but she's the one that he leaves, he extricates himself, and she's the one following. That was the point I was trying to make.
I'm hoping you can address the closing argument issue.
Before you get there, can I have one more
Please,
question on this topic? What is the prejudice that you identify
Well,
from joining these cases?
Well, that in particular, in this particular case, that he wasn't able to receive a fair trial because even though the Commonwealth will point and say, well, they were able to ascertain and determine the different case elements because some of them were guilty, some of them were not guilty. But the case that the Commonwealth particularly points to, Commonwealth versus Sway, was a homicide case where the homicide was joined with gun-related charges. But in that particular case, the defendant was exonerated of all of the gun charges. So the second case that was joined, he was found not guilty of all of those charges. So the court stated in that particular case, yeah, there is no actual prejudice because, hey, all those charges that were joined, he was found not guilty of. But in our particular case, he's found guilty on both cases. He's found guilty of the assault and battery with the dangerous weapon, and he's also found guilty of violating the one remaining count of the restraining order. So
Was the restraining order was entered as an exhibit, but I couldn't tell if the copy in the appendix was a copy of the document as it was admitted in evidence. Was it redacted in any way?
I apologize, Your Honor. I don't believe it was, but I don't want to, I don't believe her name or anything like that was redacted.
No. Did it contain the a finding by the judge that there was credible evidence to support issuing the restraining order?
I understand your question, and I do believe at that point, Your Honor, that I didn't see anything that said that the judge had found credible evidence, so that may have been redacted from the restraining order.
Would you be able to submit a copy of the document as it was actually admitted in evidence?
Yes, Your Honor.
Thank you. If you could do that within a week, we'd appreciate it.
Yes, Your Honor.
All right, sorry, Justice Neyman.
No apologies necessary. Closing argument. You raise a number of issues, and let me preface this first question with the fact that the Commonwealth is held to a different standard than defense counsel. But much of your argument is that the Commonwealth made an error by using the term we in closing argument. We know, we learned, we see. If my math is correct, And ironically, we're in the one jurisdiction in the world where there is living proof on this campus that my math should not be trusted. But with that said, if my math is correct, defense counsel used the term "we as well" 14 times in closing argument. It seems like it's a euphemistic, folksy way of speaking. Defense counsel in civil and criminal cases and plaintiff's counsel and prosecutors use it constantly. As long as the prosecutor follows up the use of the term "we" by referencing the evidence at trial, is there really a problem using that term?
Yes, defense counsel in particular in this case did also use that, and that's sort of a sort of statement or colloquial term that a lot of defense attorneys use during these cases. But as you stated, I would suggest respectfully at the beginning, was that the Commonwealth is held to a different standard,
Sure.
and they sort of do have the brandishing of the government on their side, because although we're representing an individual, they're representing the Commonwealth of Massachusetts. And in particular, with what the prosecutor did in this particular case, giving the sort of story about her own half-truths and going to a bachelorette party and then having to go home, then she started stating that, well, we know what particularly happened. We know the real truth, sort of asserting herself in the jury box or assuming that she has some sort of knowledge that is outside of what's been presented in the particular case.
We know the full truth is probably not the prosecutor's best language, and it's problematic. But what of the fact, and I'm looking at volume 2, pages 15 and 16, that after the prosecutor said, "We know the full truth," she said, "And what is that truth? Well, we know because," and then she referred to the evidence. She said, "We have these exhibits. We have the photos of her injuries." So as long as the statement is grounded in evidence, how is it prejudicial error? Or in this case, I think substantial risk because there was no objection.
Yes, it would be the substantial risk of miscarriage of justice, Your Honor. And I do agree with certain parts of that. She did reference facts, but then she also referenced facts that were not in evidence when she's talking about the "we know," because in one particular incident, she stated that the wife had screamed for help when the window was being put up on her arms, which never occurred. She never screamed for help. She never asked for the gentleman to put the window down or anything of that. So there are instances where she's referencing facts in the case that are supported and corroborated, and that would be proper, but there's also other instances where she's making statements that are incorrect and still saying "we know." I see the red light.
I
Your
know, let
Honors.
me just see if there are any further questions. Do you have anything else?
No, thank you.
No, thank you.
Thank
We'll
you,
have
Your
to
Honors.
leave it there. Thank you for your argument. Attorney Cohen? Oh, we're just going to take 15 seconds. Anyone needs to go or come. Okay, seems like a stable crowd.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. If it's all right with the panel, I'll start where my brother left off talking about the closing argument. So, of course, I would not argue that this was the best choice of words. However, I believe when looking at the closing argument, we need to look at the context within the entirety of the trial. And I also think that we need to look at the context regarding how the words were intended and the meaning behind them. And so I think as far as the half-truths, full truths phrasing went, the intent of the prosecutor appeared to be that she was introducing to the jury the idea that the defendant's testimony largely corroborated the victim's testimony, and she was urging the jury to find the victim's testimony credible where...
If only she had said it that way. I mean, I hated when I was asked this question, by the way, when I was in your position and judges would ask this question to me, but I'm going to do it anyway. Geez, if you were going back to your office today and speaking to that prosecutor, would you say, "Hey, great idea to come up with a story about what happened to you at a bachelorette party and analogize that to what happened in the facts of this case"?
No, Your Honor, I would
I mean,
not.
that's a problem.
It was ill-advised. It was definitely, it would have been better left unsaid, for sure. But again, I think the intent behind it was not to vouch for.
So I have a question about intent. Why does that matter? Because aren't we looking at the closing? I don't think anyone, I'll just speak for myself, I don't assume the prosecutor had any bad intent in structuring her closing this way, and that doesn't even matter to me. I mean, it would matter to me if I thought that she did. But because what we need to assess here is whether it had an impermissible, by structuring her closing in this way, she led the jury into impermissible considerations, right? So that's what's concerning me. So accepting that she had no bad intent, can you please address why we shouldn't be concerned about what effect this may have had on the jury's thinking about the case?
Sure, Your Honor. And I would just clarify that I suppose when I said intent, I didn't mean her personal intentions, but I suppose the meaning of the words in the context that they were used, regardless, I guess, of her choice of words.
See.
So I believe the cases that look to this sort of issue do look at what the meaning was of the words, whether the prosecutor was actually telling the jury to believe something that they didn't already hear as testimony or that sort of thing. I believe in either Penn, that was considered. However, and I will acknowledge the fact that there are quite a number of things that my brother raised. So as far as the half-truths, as far as the we know
the truth, that we know what the full truth is, we know that those things are really not a good idea.
It was an inartful way of articulating her argument. So I would.
Can we look at the prejudice piece of it?
Yes.
Well, I say prejudice, but it's substantial
Substantial
risk. So it seems to me a lot of the Commonwealth's argument on both, as to both of the defendants' arguments when it comes to the prejudice prong, like what is the impact of this? You point to the fact that I'll call it mixed verdict. There were some convictions, but several acquittals as well. I understand that. What's confusing to me, though, is I can't tell what the defendant was convicted of and what the defendant was acquitted of. I can't tell, and I'm hoping you'll be able to help me, what acts are attached to which charges. So I agree with Your Honor that it wasn't necessarily clarified. However, So the jury were never told, for example, there are 4 charges of assault and battery on a household member. And no one ever tells the jury what those 4 charges relate to. And we don't have the verdict form, so I don't know. I take it there was nothing indicated on that.
I don't believe there was, Your Honor.
Okay. Same with the 2 ABDWs. So what's bothering me is what confidence can we have that the jury didn't just, in the absence of any guidance, didn't just sort of say, like atmospherically, oh yeah, an assault and battery on a household member occurred, and assault and battery with a dangerous weapon. How is it that we know what they did, and that the fact that they acquitted on some of these charges actually means something that we can use in assessing prejudice?
So, Your Honor, I would argue that, while I agree it's not clear, I would argue that based on the testimony of the defendant and how that corroborated certain of the charges. So, in essence, when the defendant testified, he agreed that he rolled the car window up on the victim's arm. And I think in his initial testimony on direct, he did not say that it was an accident. I believe that he said She saw that I was rolling the window up, and she couldn't stop it from rolling up. The window went up and got her fingers. I rolled it down, asked her, "You okay? Don't put your hands in there." That, in combination with the photographs that were admitted as evidence, as well, of course, as the victim's testimony, I believe would prove that that was the instance of assault and battery with a dangerous weapon that the defendant was convicted on.
All right, so they rejected, though, one of those. So what are you saying they rejected? The second rolling up of the window?
Yes, and I believe that's what the attorneys discussed with the judge at
Sounded
sidebar.
like that. All right, so can you talk about the 4 charges of assault and battery on a family member? Which one was he convicted of?
So again, I agree, and I did add a footnote in my brief
Don't
that
know.
I'm not sure exactly. However, again, we do have the photographs of the victim's injuries, and there was significant bruising, especially on her arm area. So she did testify to being pushed and pulled, and it's not, I mean, it's reasonable that if they believed the defendant's and the victim's testimony regarding the window and believed that she had marks because of the window, then they could say, okay, she does have other injuries, and I can't say exactly what they agreed those were from, but it is perhaps clear that they agreed there was an injury during that pushing and pulling incident.
Okay, so if I understand your argument, I'm not trying to suggest there was not sufficient evidence for the convictions, but I guess what you're saying is the fact that they were acquitted, that the defendant was acquitted of several of the charges, indicates that even though we don't know what he was acquitted of and exactly what he was convicted for, I mean, we know what he was convicted of, but we don't know what it's factually based on. We can see that the jury was not sort of swept away by the closing.
Yes, Your Honor. And I would say that is because of the corroboration of the victim's testimony. The judge also provided an instruction to the jury that each charge should be considered separately. And of course, because of the acquittals, I believe that tends to show that the jury did weigh the evidence properly.
Could you turn to the joinder? What's puzzling me here on the joinder is if you just tried, if the Commonwealth had only tried the charges stemming from the Home Depot parking lot night, how would the subsequent, I'll just call them bad acts, have come in?
Well, Your Honor, I think Justice Shin did make a good point on that the recording of the victim during the second incident tended to show, from the Commonwealth's perspective, that this was a person who was acting very callously towards the victim. And I think that kind of goes with the Commonwealth's theory that the defendant really didn't care, wasn't considering the victim's physical safety during the incidents at the Home Depot.
Do you have a case for the admission of subsequent bad acts for that purpose?
I do not, Your Honor. But I would also argue that the case doesn't turn on that issue.
Okay, but I'm just trying to get a sense of admissibility of the evidence of the separate crimes if the cases had been tried separately. In the 209A case, how would the underlying facts leading to the issuance of the 209A order have been admissible in a trial solely on the violation of the 209A order?
I again believe that those would be admissible as prior bad acts going towards the state of mind of the defendant during the incident. It's not for propensity purposes.
What's the state of mind that's required on the 209A violation?
I think it's all one and the same. I think it's just to show that the defendant's state of mind was, he was very flippant, I suppose, about the situation. I think the
But
mocking.
what is the Commonwealth's not required to prove any state of mind in the 209A violation?
No, but I suppose it goes towards the issue of guilt. His state of mind, and it's probative towards the issue of guilt. His state of mind in either incidence
I thought
could
the
be.
only state of mind required in a 209A or violation is that you knew of the order.
I'm sorry, Your Honor. I suppose I'm not going to, speaking of the elements of the 209A, more, I suppose, for it's relevant to the defendant's state of mind during the incident because it makes it more likely than not he acted in the way that the victim is claiming that he acted. I agree state of mind isn't necessary to prove the charge. I believe that state of mind is just relevant to the Commonwealth's theory of the case and the history of the relationship and providing context to the relationship and the situations.
So the fact of the 209A, subsequent 209A order would not have been admissible in a separate trial on the assault and battery charges, right?
I suppose I'm not arguing that the 209A would have been
Right.
admissible. However, the incident,
Right.
the behavior.
But the actual issuance of the 209A would not have been admissible. And the way that that principle is often phrased in the cases is this question often turns on whether the evidence would be admissible. Is that a requirement or is that part of the overall analysis?
That's just part of the overall analysis. I think that the case law said it often turns on that.
Right.
However, I would also argue that, of course, you have the question of whether joinder is appropriate or not, but even beyond that, you have the question of prejudice. So I think whether or not it's admissible is something to consider, but it doesn't end the analysis. And I believe that here you have cases that are intertwined. You have the same victim, they're a month and a half apart, close in time. You have the context of this marriage. They've been married since 2005. There's a breakdown of the marriage. I think there are a lot of factors that connect these two cases that would require, you'd be admitting the same background in both trials.
And are you relying on the, what I'll call the mixed verdict to demonstrate the lack of prejudice with respect to joinder as well?
I am, Your Honor, but I would also say that as much as I would say that joining the two cases was also not prejudicial to the defendant because it was helpful towards his defense as well. His defense was essentially this was a woman scorned who was lying to the police when she found out more about the affair. And so by joining the two cases, the defendant he had the same defense on both cases, that this was an accident. He didn't deny being at these two places, but it was helpful to him to show that the history of their interactions as well.
I just have one more question. Back to the closing argument issue. There were 8 total counts in the complaint brought here.
I'm sorry, 8?
Were there 8 total charges in the complaint brought here that were tried?
There were 9 total charges,
9.
one of which was dismissed.
Math again, but okay, so 9. Did the defendant seek a bill of particulars in this case? Move for a bill of particulars?
I am not sure, Your Honor.
Okay. Did either party seek a special verdict form, or was it just a general verdict for trial?
I believe it was just a general verdict, but I can confirm for the court if.
I'm sure it's in the record. Thank you.
Thank you both.
Thank
The
you.
case is submitted. We're going to pause just to let people come in and out if they'd like. But the attorneys for the next case are welcome to come up.
We don't have. I know. It doesn't look
get to that, because they weren't told. And I didn't see any motion for particulars.
There is, but I just want to check.
I went through the docket for that. Okay. We have to, I know you're chomping at the bit, but we have to wait for people to get in and
No, I
out.
was just, nothing personal, I was just trying to line this thing up right,
I
so.
got you. Okay, I think we've gotten settled enough. The next case is 2023 P0138, SONA PILLAI versus David SCALIA.
Good morning, Your Honor. I'm Tim Burke, and I'm here for David and John Scalia. They're not the Scalias. That may not
Okay,
be
so
helpful here,
Scalia.
but.
Thank you, Attorney
A
Burke.
different family. The facts we have here, I believe, are relatively brief, and I will just make a brief presentation as to what those are.
You may want to keep your voice up a
Oh,
little
sure.
bit.
I always worry whether I'm not going to blow with a microphone, blow people right off the
Don't
stage,
worry.
so to speak. The facts here are relatively brief, and I'll just give a short statement as to what those are. Priscilla Scalia, who was the mother of Christine Bohenko, entered into a deed in 1993. The deed included Priscilla's name, who I unavoidably call the decedent here at times, and the names of Christine and her then husband. The deed had a unique feature in that you had Christine's name, and then, you had the mother's name, and then you had the daughter's and the husband, then husband's name, with a handwritten indication at the top. That's relevant here as to the plaintiff, the Scalias maintain that, in the facts most favorable to them, that fact should be interpreted as indicating a joint tenancy only between the husband and the wife.
Now, this was decided on a motion for summary judgment,
Yes.
correct? So why are you suggesting that we take the facts in the light most favorable to the Scalias?
Because they're the defendants in the case. They're the opposing party.
Oh, they were.
I didn't.
I
you
know, for a minute, I
didn't.
usually don't think of summary judgment going from the plaintiff's side to it was the plaintiff's motion for summary
It was,
judgment.
yes, Your Honor, it was the plaintiff's motion for summary
So-
judgment.
I want to make sure I understand your argument about the 1993 deed.
Sure.
You're saying that the handwritten notation as joint tenants applies only to Christine and Gregory because why?
Because of the unique way it appears. The deed obviously was hand done at the closing. The way it was set up, there'd be no reason to do that, because if you're just looking at the document itself, the face of the document, there was enough space underneath the line to put in as joint tenants. So the argument there is that raises a serious question as to what their intention was.
It doesn't raise a serious question grammatically, right? You'd agree with that?
Well, it only evidentiary, I would disagree, but the intention there it seems to me there'd be no other reason to do it that way. That's the argument we're making. There'd be no other reason to handwrite it there when you could have put it underneath.
So it's just
It just creates
it's
evidence.
the placement of the handwritten language?
Yes.
That's you're not arguing grammar.
Not that I know of.
Okay.
Grammar may not have been my
So you're
strongest point in high
arguing
school
that
either.
because it's placed over in the right margin as opposed to on the line below,
Right.
there was a sufficient disputed issue of material fact to defeat summary judgment.
Right. That's the argument I'm making there.
Do you agree that General Law, Chapter 184, Section 7 applies to this situation? In 184, Section 7 states in relevant part, in a conveyance to 3 or more persons, words creating a joint tenancy shall be construed as applying to all of the grantees, regardless of marital status, unless a contrary intent appears from the tenor of the instrument. So do you agree that that statute applies to this situation?
I would think, my argument being that the phrase, unless a contrary intent appears.
From the tenor of the instrument.
Right.
What does tenor mean in the statute?
My argument would be from looking at the instrument itself. All we have here is writings. The decedent cannot speak. So all we can rely upon in interpreting the document is the face of the document.
Okay, so if we were to conclude, as the judge below did, that from the face of the document, the handwritten interlineation refers to all three of the people on the deed, then what?
Then we get to the next factual situation. All right. Then in 2002...
And that's because you don't have any factual information bearing on the intent of the decedent, Priscilla.
Right, all we have...
You don't have any countervailing intent, anything to counteract the statement by the daughter in her affidavit as to what the party's intent was.
Just the document itself.
Yeah.
That's all I can...
If that fails, then
Yeah,
there's nothing else.
That's the problem with something which is 20
Okay.
years old, and I believe the mother has been dead for about 10 years, approximately. So that's the only evidence we have there in terms of the 1993 deed. Then when you get to 2002, Christine and her husband get divorced. So what is created as a matter of law, even though that was disputed at the lower level by my opponent, that creates a tenancy in common.
That was not disputed, is that what you said?
No, I believe my opponent did dispute
Okay,
it.
I mean, it's hard for me to see how a transaction between two of three joint tenants terminates the joint tenancy vis-a-vis the third joint tenant. Right, so it seems that the 2002 transaction created a tenant. Christine then owns a third, Gregory's former interest as a tenant in common, but the joint tenancy between Christine and Priscilla is still intact.
I believe even the Superior Court rule, that creates a
Right,
tenancy.
I know you did. I'm questioning whether that's correct.
I believe
as a
that is
matter of law.
I believe that's correct as a matter of law because it goes back to law school that
That was a long time.
when you sever a joint tenancy, it becomes a tenants in common. You know, that,
Do you have a case that says that in the context of more than two joint tenants?
I don't have to rely on my brief. I don't have it in front of me. But even the Superior Court found, and it's not under appeal here, that it created a tenants in common interest. So then, where does that leave the parties? We have a tenants in common interest, and my argument, of course, is that Priscilla's interest becomes an asset of the estate. And that's where it should have been adjudicated.
Right, but the judge determined that on this record, there was no material issue of fact raised about Gregory and Christine's intent in 2002, that they were not intending to transform the joint tenancy in between the mother and the daughter into a tenancy in common.
I believe we argued that the only thing that, I'm calling her Christine, makes it easier, I hope this is acceptable. The only thing she wanted was the interest from her husband. Her mother wasn't involved in the transaction. Her mother didn't sign the deed. So Christine received what she wanted from the divorce. Her mother wasn't a party to that transaction.
Right, there was nothing to indicate that the mother was intending to, or Christine, the daughter, was intending to transform the joint tenancy between them in 2002.
But that assumes it was a joint tenancy in the first place.
Assumed that there was a joint tenancy in the first place.
Assuming that there was a joint tenancy in the first place. Often by themselves, the mother had no interest and no statements. There's nothing in the record. What you have is that you have somebody getting divorced, getting an interest in property. And then the argument arising subsequent to that effect, subsequent to that deed, there were two refinancings. One doesn't say tenants in common, doesn't say anything. All it says is mother and daughter. The critical evidence that I think the Superior Court overlooked was there was a subsequent mortgage in 2003. And uniquely, it says half to the mother and half to the daughter.
That's not inconsistent with a joint tenancy. That was their interest.
Well, it's also very consistent with the tenants in common.
Could be either way. It's not inconsistent with either.
But, you know,
It's not proof of one or the other. It's just not inconsistent with either.
okay, I may disagree, but because it's extraordinary to go to that length and put it in.
It's not the same as saying tenants in common.
Right.
Right?
But it is evidence as to what the decedent saw.
Also, I mean, even if a mortgage document said tenants in common, that would not actually be sufficient to create a tenancy in common, right?
But-
because the mortgage document doesn't bear on who actually has title or in what form.
But what it does speak to is to the decedent's understanding as to what she held. That's again, I don't have a client here. I have pieces of paper. I represent David
With respect to the 2002 deed and the 2002 deed and transaction, what's relevant is the intent of Christine and Gregory, right? Not your client.
I disagree with that because my client's interest, once the deed was transferred as a matter of law, became a tenant in common interest. The question presumes the fact that she didn't know that or wasn't informed that. And we don't know that. There's no way for us to know that. But
Well, I mean, it's a transaction solely between Christine and Gregory.
true.
And the judge found that the intent of the two parties to the transaction was not to terminate the joint tenancy between the daughter and the mother. So why, isn't that all you need?
No, because as a matter of law, the tenancy was, strictly as a matter of law, the joint tenancy was terminated. Even if it was a joint tenancy,
No,
it was
the
terminated.
judge found it was a mutual mistake, right? And that the deed should be reformed.
But in order to be a mutual mistake, the decedent would have had to have an
No,
interest.
that's what I'm asking,
Yeah.
is how could somebody who's not a party to the transaction have made a mistake about the transaction? She wasn't a party.
Right. So she couldn't have made a mistake, so it couldn't
So
be
the
mutual.
sole question is whether there was a mutual mistake between the parties to the transaction, which were Christine and Gregory.
Or I believe the question is, in order to have a mutual mistake, you can't affect a third party. And by them transferring the deed the way they did, my client's interest became a tenants in common's interest. And to change that as a matter of law, it would have to be a mutual mistake as it relates to the decedent. And so, I mean, you have a deed which is arguably inconsistent on its face. I mean, you can accept, you have your view, I believe the facts can maybe support the notion that it wasn't intended to be a joint tenancy with the mother.
For the doctrine of mutual mistake, and I think this is just another way of restating what Justice Shin is asking you, do you need to show mistake on the part of anyone other than the contracting parties?
If it affects someone else, I believe you do.
Do you have a case that says that?
I believe in my papers, I
don't-
support that notion.
That a third party, a non-contracting party's intent is necessary?
Because that would affect her interest. How could it be a mistake on the fact that somebody whose interest has been changed if she isn't part of the transaction? It's logically impossible that if her interest is going to be changed, it would have to be her mistake.
Let me see if there, oh, sorry, you still have a minute. I thought it was the red light, I'm sorry.
No, I'm sorry. I mean, I'll sum up very quickly here that there's other facts in the case. There's been some arguments that David's filing of voluntary administration creates some estoppel. I maintain it does not, particularly since the probate court allowed the petition and let him become personal representative during this litigation.
And what's the status of that probate petition?
It was approved. But nothing has happened because the only real asset of the estate, this is the asset of the estate.
Okay.
The 50%, other than that, there is no asset of the estate. I mean, of any consequence that I'm aware of. And also there's been some discussion about the verbiage in the decedent's will. And the position that John and David maintain is that why would their mother give them a property that she didn't have an interest in? That makes absolutely no sense. The language
doesn't the language of the will says if I have such interest in
right,
property.
which she could have sold it, she could have given it away. So again, in the light most favorable to John and David, in the light again, it's a legitimate question, but in the light most favorable to them, and we're talking about summary judgment, she was giving them the property. Is there any further questions? The last comment I have is that there's no reason that someone should receive a benefit as Ms. Bohanko did when my clients have done nothing wrong and they've been harmed here. Thank you.
All right, thank you for your argument. Attorney Looney?
Yes, Your Honor. Thank you, Your Honors. Thomas Looney on behalf of SONA PILLAI. I'm here today with my colleague Jacqueline Price from my office, who's worked with me throughout the case. I want to start by saying it's nice to be here at this great institution. I mentioned to Naomi on the way in that I was wearing my St. Sebastian's tie for the event, and then she told me that you all three went to this institution and that my power move may backfire. So I hope that's not true. So thank you, Your Honors. Having given that male couple, I'll continue with another one, which is that I have a case to cite, which I did not cite in my brief, and embarrassed to say that I didn't catch it the first time through. It's not a recent case, actually. It's from 1966. I'll give you the citation, and I bring this up because the facts are so strikingly appropriate here. It's Reeder versus Kuss, R-E-D-E-R, versus Kuss, K-U-S-S, 351 Mass 15. As I said, a 1966 case. In that case, Reeder and Kuss, a man and woman not married, decided to purchase property together and live there together. They were Polish immigrants. They wanted to set up their ownership so that if one died, the other would automatically become the owner. Whoever drafted the deed wrote it as tenants in common on the deed. Reeder passed away. Kuss claimed the full ownership. Reeder's family objected, and the court determined that the intent of the parties, as testified by the survivor, would control and reform the deed to change the tenants in common tenancy to a joint tenancy.
Was that after trial?
That was after trial, but it was 1966. It was before the summary judgment was established. But
so one of my questions for you was, what's your best published appellate case for the proposition that not only was there a mutual mistake here, but that the appropriate remedy is reformation of the contract? And is that the case you would now cite?
That's the case, Your Honor. Yeah, and I'm sorry I didn't cite it in the brief initially.
Do you have a case that involves more than two joint tenants?
I don't think I do, Your Honor. But your question previously about the tenancy brings up a sort of a sticky issue, because there's a real debate in the conveyancing community and surrounding the four unities and whether a deed that we have here does automatically break the tenancy. Some say yes, some say no, which is probably maybe explains why it didn't get picked up at the purchase or even the first refinancing.
But that debate has occurred in the context of where there are two joint tenants and there's a conveyance by one, right?
Right.
Are you aware of cases where there is more than two and there is a transaction between less than the total number?
I'm not aware of a case with that factual scenario, Your Honor. But again, I don't think it necessarily matters because the case law for, decades has been that a deed should be reformed if it doesn't conform to the party's intent. Deeds and other instruments, for that
I'm just
matter.
looking though at Reader versus Cuss, and it looks like it was a petition in equity filed in the probate court.
It was, Your Honor.
So would that make a difference?
No, I don't think so, Your Honor. I mean, it's just a question of whether the court has jurisdiction. Superior Court in this case had jurisdiction and equity jurisdiction.
Superior Court had jurisdiction, but the reformation here was pursuant to the count 2, is that it? Count 2, which was the count seeking to quiet title?
Yes, Your Honor.
Because I don't think you
believe
could
that's correct.
probably give that relief on count 1, which was for declaratory judgment.
Well, I think it could be either one, Your Honor. Typically, I would have included a specific count for reformation, but didn't in this case initially. The focus was on, I think, the prior deed rather than the latter deed. But I suspect that I would have amended at some point to add a specific request for reformation. The judge sort of short-circuited that for me.
So is your primary argument with respect to the second deed that it was a product of mutual mistake and should be reformed, or is your argument that it did not transform the initial deed from a joint tenancy into a tenancy in common?
I would say at this stage, Your Honor, I'm going to rely mostly on the reformation based on the intent, but the way we pled the case and argued it even from the complaint really does rely on the intent of the parties, whether it's a declaratory judgment or a reformation or a quiet title. The bottom line was we were arguing that the intent of Gregory and Christine was not to break the tenancy by the recording of this deed. It was simply to clean up the issue between the two of them that arose in the context of the divorce. There is no evidence that anyone, Christine or Gregory or Priscilla for that matter, had any different intent. And the only intent we have was Christina testified that her mother did want a joint tenancy, and we have the initial 1993 deed. There's no evidence at all that she had changed her mind at that point. Regardless of what was happening between Christine and Gregory.
I know these 4 unities throw me off.
You're not the only one, Your Honor.
Yeah. I don't know it sounds like neoclassical theater to me in some ways. But
it's a bit metaphysical, I think.
The 4 unities.
Yeah. But the statutes are helpful in that regard. And I forget, one of you pointed out, I think Justice Neyman pointed it out, 184 Section 7 really does say, you can have differing tenancies, but you've got to be clear about it. And if it's something that refers to a joint tenancy, it's going to apply to all of them. There's been some arguments previously I've heard about, well, it's different if the 2 of the people are married or if not, but the statute to me is pretty clear that the parties, whether they're married, not married, 2 of them, 3 of them, however many number, they can create their own tenancy as they wish. As I say, there's pushback in the conveyancing community about the 4 unities and whether you can even do that, but I think the statute, at least as it applies to this case, is very clear that you can create a joint tenancy among the 3.
I have some recollection that our law regarding the 4 unities is not exactly the same as other jurisdictions.
It wouldn't surprise me, Your Honor.
You're aware that the issue of the 4 unities is sort of pending in front of the SJC at the moment?
I am aware of that, and I don't remember exactly the facts of the case that's before them, but a lot of times, from my experience, not necessarily in cases, but just in title matters and debates with other people in the title world, there isn't, I don't think, enough emphasis placed on the statutory language that's there for us to use. And I think there's much more of a reliance on the sort of 100-year-old plus concept of the four unities that I think is a lot less clear, in my mind anyway. And I think that the Superior Court judge in this case, saw the evidence for what it was. You really had evidence from our side as to the intent, and you really had no evidence from the other side. And I should point out, I wanted to just briefly talk about the record on appeal and the summary judgment record, because I think there are certain portions of the appendix that really, they weren't part of the summary judgment record, weren't before the Superior Court judge at the time of the hearing, and I think aren't really appropriate to be in the record on appeal, because obviously your de novo review has got to be based on the summary judgment record.
These are the documents that came in connection with the subsequent motion to
strike my argument, yes,
Right.
Your Honor. And, I don't shy away from that. I'm not asking you not to read it. You probably have already read it. I'm sort of
sure
proud
we
of the
have
response we
already read
gave, but I think, I don't think they're part of the record. And I would point out appendix pages 276 to 292 just shouldn't be considered, in my opinion, because the
Could I
judge
ask
didn't
you
have it.
about the bona fide purchaser issue? So let's say that the 2002 deed terminated the joint tenancy, which you've probably guessed I'm not sure is correct, but as a matter of law, I'm not sure that's correct. But let's just assume that it did. Why wouldn't that put your client on constructive notice?
Well, I think for the reasons we've talked about, it may not be 100% clear. If you have to think about an examiner going down to the registry and taking a look at this, as we've seen, the examiner at the time of her purchase didn't pick it up.
But someone eventually thought there was an issue,
Someone
right? So
eventually
what does
did.
constructive notice mean in this context?
In this
How much notice does there have to be?
I mean, typically it means that if there's an instrument in the registry of deeds or the registry of probate that would put a reasonable examiner on notice of an issue.
Reasonable examiner is the
I
standard?
believe that's the.
So how do we assess
standard.
that on this record?
I don't think you have to, for one thing, because SONA PILLAI, my client, is an individual who bought this property, and she paid full value for it. She had a lender who lent her the money to buy it, who hired their counsel. They're the ones who did the title examination. That counsel did the, wrote the title policy. SONA had nothing to do with that. That if any of the professionals that were handling this made a mistake, that shouldn't be attributed to her. And so, my response, I guess, would be that, she doesn't have constructive notice of it. Because it's not entirely clear from the Registry of Deeds the effect of these two, the 2002 deed in particular. And, she's just a layperson who hasn't run the title herself. So I think, I don't think there was constructive notice on
So
it.
if someone buys a property without hiring someone to do a title examination, they're not on constructive notice?
No, they are on constructive
Okay.
notice. You're right, they are.
So
But I think in this case,
how do we, you said that the standard is whether a reasonable examiner would have discovered the defect. So how do we decide that?
well, I actually don't think you have to. Again,
Okay.
because if you think about a bona fide purchaser, a bona fide purchaser is someone who pays value without actual notice of someone's prior claims. So the argument is that she had no notice of David and John Scalia's claims because they never put any claim into the Registry of Deeds. I mean, they happen to be here because they're the heirs of Priscilla. And when counsel talked about his client, he wasn't referring to Priscilla. He doesn't represent Priscilla. She died, many years ago. So SONA PILLAI had no actual notice of any claims by John or David. That's the bona fide purchaser analysis.
How does constructive notice come into the analysis?
Well, constructive notice comes into the analysis if you're a subsequent purchaser. Let's say there's a deed. typically it comes up if someone has a deed that they hadn't recorded yet. And a subsequent purchaser then comes in and, doesn't have notice of the deed through the registry of deeds, but has seen it because they're related to the person or for some reason had actual notice of it. They're still behind that deed. They're still, their interest would be subject to that deed, even though it's not in the registry. But if it's in the registry, they do have constructive notice of it. In this case, I would say that I think the issue was not clear enough to give constructive notice based on that 2002 deed. That's how I would respond.
There's a dispute in the record, not in the record rather, but in the briefing as to which party has the burden of proof in determining whether your client was or was not a bona fide purchaser. Who has the burden and what's your authority for the proposition?
They have the burden, the person challenging bona fide purchaser status has the burden in real estate cases. In other cases, it's not the same. In cases involving personal property, it's the opposite. Lee versus Richardson, I believe is the case. I have it. We did cite it in the brief.
Your brother says that the burden of proof becomes that of a person challenging the status of a bona fide purchaser only when involving the issue of an unrecorded document.
I don't think that's true, Your Honor. I think in cases involving real estate,
it cites the same case, Richardson
versus Lee Realty. Yeah. Okay. Burden of proof is on the party claiming non-BFP status. And in that case, the purchaser at the sheriff's sale was deemed a bona fide purchaser despite the existence of claims that were already in the probate court, but maybe not necessarily obvious. So I would rely on that case.
I don't see any other questions. It's an interesting case. We've been helped by your briefing and by your arguments, so thank you very much.
Thank you, Your Honor.
And with that, the case is submitted. So that concludes our list for today.